Welcome to today's program titled Supreme Court Hughes Ruling Stokes Increase in ERISA Class Action Fee Litigation. At this time, all participants are in a listen-only mode. For those of you who are logged in to the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down, as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On this slide, you will see our legal disclaimer. At this time, I would like to turn it over to our first speaker for today's program, Sam Schwartz-Fenwick. Sam, please go ahead.
Thanks so much, and thank you everyone for joining us today for this 30-minute webinar. We have a bunch to cover, and we also want to make sure we hear from you with any questions or thoughts. So with that, let me jump right in and just introduce myself. My name is Sam Schwartz-Fenwick. I'm a partner in our labor and employment group, as is my colleague and co-presenter, Ada Dolph. We're based in Chicago, and we've been in the trenches on the fee litigation that we're talking about today since their inception in 2005. And with that, and to give you a high-level overview of what trends we're currently seeing, let me turn it over to Ada.
Thanks, Sam. So Hughes is sort of the latest development in a trend that we've seen going in the wrong direction for plans over the last few years. And we've been keeping you posted on this trend over the last couple of years. And I guess I can report that it's continuing unabated. And we do expect the Hughes decision to impact this as well, which we'll get into in just a minute. So ERISA 401k fee and 403b fee lawsuits were relatively rare in prior years, but they started to pick up in fourth quarter 2019. They really picked up speed in 2020 with over 90 filed in 2020. The pandemic seemed to slow things a little bit, but we still found a similar number filed in 2021. And we've also seen some patterns in terms of industries that are targeted. So what we're seeing, there was a time when universities were targeted. It's been a little bit more general over the last couple of years, but we're seeing a trend in 2022 where hospitals and health systems are the primary targets of these cases. So if you're in that industry, this is something that you should be taking a look at because it's likely someone is pulling your Form 5500s from the Department of Labor and taking a look at the fees that are being charged to your plan participants and the investment offerings that are being offered to your participants. Matching this and sort of going along with it, we've seen a number of new law firms get into the business of these cases. It used to be limited to just a couple, and now we have a number of different players in this field. We're also seeing a willingness to bring these cases against much smaller plans than usual. So I guess what I would say from our perspective, no matter what size plan you have, these are the types of things that we'll talk about that you should be paying attention to in 2022. And then complicating matters, which Sam will get into a little bit more, is we've seen an erosion over the years of courts' willingness to dismiss these cases early on procedural or claims, failure of state claims grounds. So we see statistically, typically, and I think it actually has gotten worse from an employer or plan perspective, 2 of 3 complaints survive motions to dismiss. So these cases are moving forward in the process. Next slide. So some of the common claims that we're seeing are fairly typical from over the years. The share class argument, that is the retail versus institutional share class fees being charged, that is a fairly common claim, and we're continuing to see that. Not offering enough index funds, that is offering more actively managed funds or exclusively actively managed funds. That continues to be a common claim. And some newer ones that are seeking, it seems, to push the law a little bit further are claims that, for example, it's inappropriate for a plan to offer a fund that's affiliated with the record keeper. That's a very common practice in the industry, but we have seen some plaintiffs arguing that that is by itself imprudent, or that there's something improper about it. Those claims have not gained traction thus far, but it is something that we're seeing. We continue to see allegations that seem to suggest that it's imprudent per se to pay for record keeping fees through a revenue sharing or percentage of assets model rather than on a flat fee participant basis. Again, the courts have stopped short of saying that that's per se imprudent, but we're seeing that continue to be pushed by the plaintiff's bar. Really, regardless of the plan's history, almost every time in every complaint, we see the allegation that there hasn't been sufficient pressure testing of the fees that are being charged to participants. That is, that the plan has not done a request for proposal or retained multiple record keepers or the like without pressure testing that, as I said. And then a relatively newer claim that we've seen kind of ebb and flow a little bit is the concept that participant data, when provided to a record keeper, constitutes a prohibited transaction. And this is showing up in cases where they're arguing that the record keeper utilized participant data to market non-plan products to participants. Again, these claims have not gained traction, but we continue to see those.
Yeah, and I think that as Ada's talking about the evolution of these cases, the attacks on revenue sharing and the prohibited transaction claims, even if they're not ultimately successful, what they do is they're an attempt to kick up some mud to make it harder to dispose of an entire case on a motion to dismiss. And we're continuing to see that as these cases evolve, that it's really, they're developing new theories to more ably be able to withstand motions to dismiss, because it's once you get past a motion to dismiss stage, even if the claim does not really have any merit, the cost of going through discovery and briefing summary judgment can be so high. And at the end of the day, it's a battle of the experts. And so that cost analysis means that when you survive a motion to dismiss, if a claim survives, the pressure to settle and that cost benefit analysis can really push towards settlement. So the title today is Hughes, and it's obviously about this Northwestern decision that was issued last week. But I want to give a little background. So a core issue in terms of whether or not these fee cases have traction is, what does a plaintiff need to plead to survive? Ada mentioned some newcomers in the market in terms of people bringing the cases. The new lawsuits, they almost read like carbon copies of each other. It's the same bare bones complaint being filed over and over again, and all they're doing is swapping out the name of the plan and whatever 5 or 6 investment options or 20 investment options they want to target, but it's largely the same complaint. And so with that, many were hopeful that when this went to the Supreme Court would say, this kind of boilerplate, even if it's a 30-page complaint, if it's all generalized and not specific to this plan, you haven't met their pleading standard, or the pleading standard. So prior to this Hughes case coming up, even though the courts amongst themselves denied it, there was a clear circuit split, where in the 8th Circuit, for instance, we cite this Braden case, which was one of the first cases, but more recently in the university context, there was a case against WashU that had the same holding, which was a very low standard. They said, merely alleging that you could have offered index funds that were comparable with the, actively managed funds, that was sufficient to state a claim. In contrast, the 7th Circuit in a case called Devane, which is the precursor to Hughes. They just had to swap out the name of the plaintiff, took a really different view. And it was clear that the Seventh Circuit was motivated by a view that the bulk of the law in this area that was allowing these cases to survive a motion to dismiss was really embedded in a paternalistic view of participants, and that participants couldn't make decisions for themselves. Plaintiffs were arguing the plan has too many choices. It's imprudent to offer so many choices. Some of your fees, some of the investments offered have high fees, others have low fees. This is too much for people to deal with. There was really an air of paternalism, and to Ada's point before, there was also just a lot of attack about something being inherently wrong and inappropriate with revenue sharing. So what the Seventh Circuit held is, in short, was I don't care that your complaint is over 200 paragraphs long. That's not enough. Part of the holding was, as long as you offer choice and there were low-cost options with plaintiff don't dispute are prudent, then you should be able to, your claim fails because no one was making you invest in these high-priced options. At the same time, though, the Seventh Circuit went on to say that, it did get in the weeds here. And it said that merely because other record-keeping fee structures existed, that doesn't mean it was imprudent to go with the record-keeping structure chosen by the university. And indeed, the court pointed out there are business reasons why the university made the decision that it made. And it held that same holding for the plan options that were targeted. So many people hoped when the Supreme Court took this case that it would clarify this dispute, that it would talk about what does someone need to plead in order to state a claim of imprudence, both relating to specific investment options in a plan and also with respect to the record keeping or administrative fees paid by the plan. The Supreme Court didn't do either of those. Instead, in a very narrow decision, the Supreme Court simply held that the Seventh Circuit was wrong in focusing any part of its decision on the fact that there were options in the plan. The court said that that's really inappropriate for a motion to dismiss, and that the analysis really has to focus on each specific decision made by the fiduciaries. Was the decision to keep this actively managed fund prudent? It doesn't matter if you have 50 or 100 index funds, it's looking at this specific fund in the thought process. The court remanded it back to the Seventh Circuit, and we'll see what happens. I think as a practical matter, the fact that the Supreme Court didn't take this case head on is probably going to increase those motion to dismiss survival statistics that Ada was mentioning. There still may be ways to, but who knows? It was a split decision. Part of the reason many people think it was a split decision is because Justice Barrett was on the Seventh Circuit when it issued the Hughes decision. If the case is remanded and the university wins again and goes back to the Supreme Court, it's very possible that when you have a 9-member court, they'll be able to break any deadlock and issue a more substantive decision. I know Ada had some thoughts. I wanted to give her the floor.
Sure, thanks, Sam. I think two things also that are important coming out of the Hughes decision that I saw the Supreme Court emphasize, which again are going to make it more difficult for these cases to be defeated on motion to dismiss, are its focus on the continuing nature of fiduciary duties. So it spends a lot of time, again, talking about that at every point, a fiduciary has an ongoing responsibility to ensure that an investment option is prudent. And I don't necessarily dispute that, but what the focus on that means that when we're making statute of limitations arguments, that will be harder to do because here we've got some language that's talking about that ongoing duty. And that's been part of the evolution at the Supreme Court here, where they're saying, well, even if you publicize a decision, 10 years ago and you made it readily known to your participants, the continued use of that record keeper, the continued inclusion of that investment option each day renews that claim. And so this continued language in the Supreme Court decision, I think, adds to that problematic piece where we're trying to argue that these cases are barred by the statute of limitations, which is contained in ERISA for a reason. The other piece of it that I think is, again, it's fitting with the trend that we're seeing is this focus on potentially on process for arriving at the decision. So we've seen this evolution from was the record keeper selection prudent to how did you decide upon that record keeper? So here in this case, for example, we have it stated that the record keeper needed to be retained because the contract required that for one investment option that was favored by participants. And here, that explanation was not satisfactory to the court. So they're wanting to look further and suggesting that there needs to be further inquiry into process. So again, these two factors are going to continue to make it very difficult, again, to defeat to defeat these complaints on motions to dismiss.
That said, I do think that, we'll see what happens with the Seventh Circuit when this comes back, because I think there is this real tension that you're pretty much, if you make it too hard for an employer or plan to win on a motion to dismiss, and you really say these claims are always viable as a practical matter, that you're really creating a huge disincentive for companies to continue to offer these plans because you're making it potentially prohibitively expensive for them to secure insurance. And I think that that's a real tension that a number of the amicus briefs that were previously submitted to the court in Northwestern were arguing that the standard can't merely be adopting what the Eighth Circuit did in Braden and saying merely alleging that a comparable fund existed, merely saying that's enough. That can't be the ultimate standard. Ida, you look like you were going to say something.
Yeah, I was just going to add too, there's a little bit of tracking if you look at the solicitor's brief. The court seems to track that rationale in which the solicitor sustained two of the claims and declined to comment on any of the other claims. So for example, the claim that sharing participant data was a prohibited transaction, the court didn't touch that one at all, nor did the solicitor's office. But the solicitor's office did argue that the Iqbal and Twombly standards, where you need to take certain allegations as true if they're substantiated and specific and supported, they argued that the Seventh Circuit did not properly apply that standard. And there seems to be a little bit of a chastise in the final paragraph of the Hughes decision where it says, it harks back to the pleading standard in Iqbal and in Twombly. So I do think there is some suggestion that the Seventh Circuit is viewed as not having taken some of the facts alleged in this very lengthy complaint, which is very typical in these cases, as true as they should have, I guess, at the pleading stage. And the one bone that the Supreme Court throws fiduciaries is the last sentence. At times, the circumstances facing an ERISA fiduciary will implicate difficult trade-offs, and courts must give due regard to the range of reasonable judgments a fiduciary may make based on her experience and expertise. So, a little bit of room there for fiduciary decision making, but as Sam said, it remains to be seen what the Seventh Circuit does with this. It certainly, for circuits that are already more lenient in this area, gives them the room to continue to be that way.
It certainly does. And I mean, you never know, just because cert is granted once, there's no way of knowing if after the Seventh Circuit rules that cert would be granted again, which means we might just be living in this space of uncertainty for a very long time, which of course will only add more fuel to the fire for plaintiffs' lawyers with dollar signs in their eyes. So let's now turn to, I'm trying to advance the slide. Let's now turn to what can we do, and what can plans do to be best positioned if and when they are targeted. So Ada?
Thanks, Sam. And it's really two-pronged. In many, many instances, we find that our fiduciaries are adhering to all of the best practices that are recommended for fiduciaries in these cases. But the other prong of it is to document that compliance so that when you end up in these cases, litigating them and defending them, you have the evidence to show that compliance. And that's the piece that's coming from this trend of increasing litigation, is a focus, at least in my discussions with my clients, on making sure that they've documented their best practice. Often we end up litigating over those minor pieces that have not been documented. So starting with having a clear written allocation of fiduciary duties that are followed, making sure your plan documents actually line up to what people are doing. The same for the charters for your committees. Make sure that these documents are reviewed, as often as you can in terms of adjusting the duties and making sure they're lining up with the work that people are actually doing. It's also helpful to have a clear delegation tree to understand who's responsible for what, to make sure that no duty sort of falls through the cracks. One example might be, for example, the investment fees that are charged for various investment options. One component of that in a revenue sharing environment is investment fees, and the other component is record keeping fees. So making sure that both of those aspects are examined and monitored. Obviously, we have in place fiduciary protections. There's fidelity bonds, which are required by ERISA to protect against theft of plan assets. It's very common for our clients to have fiduciary liability insurance, and then also to offer indemnification to committee members who serve in fiduciary roles. Again, the primary focus, as you can see from this ERISA fee litigation trend, is on the relationship between the plan and service providers. So making sure that the selection process is prudent. And as I said, consider doing some of that pressure testing that we've talked about. And there's a whole bunch of different arguments about whether benchmarking is sufficient in this area, requests for information are sufficient, or requests for proposal, really putting it out to bid. But doing these things, any of these things, can be very helpful in litigation to show that the fiduciaries were monitoring the fees at issue and making sure that they kept in touch with the fees that were being charged across the industry, and really getting the best deal for their participants. Understand the fee arrangements. We often have lots of very complex fee arrangements where there may be revenue sharing and then reimbursement back to plan participants. It's important as a fiduciary to understand this arrangement and see how it nets out for your participants. And then make sure your contracts are, fair, have clear terms, and, make sure there's a balance in terms of the liability allocation in those contracts.
And I think that the clarity in contracts should also go into our participant-facing disclosures. I think the clearer we can be when we're talking about fees and how, fees are charged, what are the fees, and really breaking it down in plain English, that can really help, because you generally can submit those as part of a motion to dismiss. And so those are helpful documents. If it's confusing what's in them, it can lead a court to say, like, well, I can't make any sense of this. How can you expect a participant to? Ida, I can't see if we have any questions. I want to be conscious of if we do, or if you just want to read them when they come in.
No, and I see one. What impact, if any, do you think the Supreme Court's holding will have on brokerage windows? Does this decision make it practically impossible to offer them and satisfy your fiduciary duty? That's been a debate that's been going back and forth, and obviously, Sam, I welcome your perspective on this as well. You know, it was seen as sort of a panacea back in the Hecker versus Deere era, when the court really focused on this amount of choice that was being offered to participants. And then through the university litigation, we've seen where too many choices has become the problem. From my perspective, I think it depends on the level of oversight over the brokerage window. I don't think, you know, if the committee has a process in place to do some monitoring around what the brokerage window offers and its fees, and routinely looks at that, understanding that it's meant to be sort of an outlet for participants who are dissatisfied with the main menu, I think that should be sufficient. I don't think this dooms that option. But again, Sam, I welcome your thoughts on that.
No, I agree. I think that that's totally right in terms of what a process should look like. I also think getting into the, you know, paternalistic concerns that were echoed by the Seventh Circuit, I think it's really problematic to say, and certainly I don't think anything in ERISA supports this view that giving people a brokerage window, you know, and more autonomy on a tax, you know, protected basis to make the best investments that they see fit. I mean, I don't see anything in this decision that limits that. I think what this decision makes clear is, you know, your fiduciary doesn't end before your brokerage window. It extends to any offering in your plan. And so I think that's just an important reminder.
Continuing on with just some tips for helping defeat liability, and I think Sam made a really great point there, that we're recommending a real focus on the documents, sort of the standard plan documents and disclosures that can be used at the motion to dismiss stage. They're often incorporated by reference or even directly attached to the complaints that will help you defeat these cases. What's harder to do is if the decision challenge is discussed only in committee meeting minutes, because typically those are not sort of widely available to participants. But nonetheless, it can come down to very particular decisions and whether they've been documented in committee meeting minutes. So make sure you have comprehensive minutes for the regular committee meetings. Get reports from your experts, investment advisors, actuaries, and legal counsel as needed, and make sure those are included and presented to the committee. Get reports from the parties that you've delegated fiduciary duties to, even though maybe you work with that person every single day. But a formal sort of check-in and oversight around a duty that you've delegated to them is very helpful in terms of litigation, showing the oversight. The oversight is always there in my experience. It's just how well was it documented that somebody was, you know, paying attention to a delegate's performance of, for example, monitoring the investment. And then if you take actions between meetings, which is also not uncommon, email dialogue and that sort of thing, make sure that those are formally documented as well. Those decisions, you know, can be at issue later as well.
Yeah, and just 2 points on that. Just keep in mind, if you are discussing plan-related things between meetings, there's a very high chance those discussions will not be privileged, even if a lawyer is on them. So just keep that in mind. And the other one is this reference to experts. You're not expected as the plan committee or the fiduciary to know everything. It's great to reach out to people who do know it, who make a living doing these types of analysis and have really clear processes that then they can submit, you know, documentation before the meeting and then present at the meeting their knowledge of what are trends, what are good choices, what should you be thinking about. That is really helpful. So I know we're running out of time, so I wanted to flip it back to Kate so she can give the CLE code.
Sam.
Oh.
This concludes today's webinar. The CLE code for this webinar is 2283. Thank you very much for attending.